Well, a seven-judge Supreme Court bench headed by Chief Justice of India DY Chandrachud has allowed the states to subclassify SC/STs to ensure the grant of quota to more backward castes inside these groups. The bench held with a 6.1 majority that states could indeed further segregate the divisions and subclassify so that the benefits under affirmative action trickle down to all those who fall under this. The judgment given by the Apex Court overrules the 20-year-old 2004 landmark judgment in the EV Chinnaiah case. The judgment given out in 2004 landmark case categorically defined SCs and STs as homogeneous groups and hence stated that the states could not further subclassify them to grant quota, inside quota for more deprived and weaker castes in these groups. Citing Article 14, the Chinnaiah judgment had held that any subclassification of SCs would violate the right to equality envisaged in the Constitution. Under the current judgment, the Apex Court has recognized heterogeneous classification within SC/ST communities and allowed the states to make subclassifications based on quantifiable results, demonstrable data, and not simply based on whims. While the bench delivered the judgment by majority, Justice Bela Trivedi dissented to the judgment, stating that the judgment cannot be justified under powers given to the states in Article 142 and violates scheduled castes list under Article 341. So as Supreme Court paves the way for creamy layers in scheduled castes, let's understand what this judgment means and whether this will be a game changer for the governments and their policies when it comes to reservation. To talk about this, joining us on the show is Advocate Ashwini Dubey, senior lawyer with the Supreme Court. Advocate Vineet Jinder, Supreme Court lawyer, also joins us on the show. Manasvi Thapar, political analyst, with us on the program as well. And last but by no means the least, Mr. Sandeep Chatra, human rights activist, also joins us on the show. Ashwini, I'll begin with you. Simple as the monologue stated when I started the show, what does this mean and how is this susceptible or vulnerable to exploitation when it comes to political ends and political pursuits within states? We have seen when the Lok Sabha elections concluded, Ashwini, how reservation and the modification in constitution, took away a large chunk of voters from the current dispensation. How is this likely to be an undertone or an important facet when it comes to vote bank politics?
There are two aspects. One, Vineet Bhai, if we see the jurisprudence on reservation, Supreme Court has categorically said that the class within the class is permissible in order to give the benefit to those who are really needed, not to those who have already uplifted. But second is, so far as the exploitation is concerned, yes, Vineet Bhai, that maybe because the states for their vote bank politics and to appease certain classes, if they come to note that this particular caste is having more numbers and their numbers, their voters, they are more, they can misinterpret it. But let us move further and talk about, as you rightly said, the Chinnaiah judgment, which used to say that their sub-classification is not permissible. But today, Honorable Supreme Court has categorically says the principal issue has decided. The sub-classification of the scheduled castes for reservation is constitutionally permissible. Meaning thereby, those who have become IS, those who have become IPS, those who have become judges from the scheduled caste or scheduled tribes community, they may not be entitled to get the benefit. Because Indira Sahni judgment, 9 judges bench Vineet Bhai, as you rightly recall, that has said that the creamy layer has to be kept out from within the reservation which has been granted by the government. 3-4 issues were here. One is sub-classification with the reserve categories is necessary. 2 is scheduled caste a homogeneous category, as you rightly pointed out. And are states competent to create sub-classification within reserve categories? But here the Supreme Court has ruled yes, the states are competent to create sub-classifications within the reserve categories, and they have interpreted Article 341 of the Constitution. And the 5 judges bench of EV Chinnaiah, that was overruled. And the other thing, the caste identified in the presidential list be a backward class under Article 16.4. Very significantly, the Supreme Court has ruled that the policy of reservation as enshrined under the Constitution and by its various amendments require a fresh relook. So this is the genesis of the judgment, and evolvement of other methods for helping and uplifting the depressed class or the downtrodden or the persons belonging to SC, ST, OBC communities. So long no new method is evolved or adopted, the system of reservation as prevailing may continue to occupy the field with the power to permit subclassification of a class. But here the duty lies on the states. But in Indira Shani judgment, Vineet Bhai, in the Indira Shani judgments, the classification as well as the directions given in that case has not been applied in true letter and spirit. There is no survey so far as those who have got the benefits of reservation, and whether they are children, those who coming on the creaming layer, there is no data, and that is all because of the vote bank politics. What we are seeing after 75 years of independence, that when Constitution does not put any embargo within the class or does not put any that there should be a difference, but the political masters for their own benefits, they are creating caste more vulnerable. So tomorrow it is going to be if the political parties, they want to say certain that the reservation or those their numbers are high, they should be given more benefits. The Supreme Court, so far as the cap is concerned, does not say anything. So far as the classification is concerned, has says that yes, those who need it, they should be given. Those who have got it, they should be not given. They should be ousted from it. It's a very landmark judgment, Vineet Bhai, and I hope that it should be implemented in true letter in spirit, and some better sense will prevail to those who are ruling us.
Mr. Chatra, in fact, the Supreme Court went on to say that this classification needs to be based on degrees of discrimination and cannot be done by states through a collection of empirical data on the representation in government jobs and admissions to educational institutes. How important is this observation, Mr. Chatra?
No, thank you, and thank you for having me here, and greetings to all viewers and panelists. I think it is a landmark judgment, and I'd like to go specifically welcome this idea of creating a quota within of the reserved category for the underprivileged caste. Now, it's welcome on 4 grounds, and I'll be addressing those questions which were raised by Ashwini ji, but also by you. The first is it clearly says that such an identification has to be done on quantifiable and demonstrable data. So that is very crucial. It, of course, the judgment indicates 2 such instances: reservation in government jobs and access or what is called enrollment in educational institutions, the educational benefits. One would have loved to see more. Question of ownership of land, for instance, which continues to depress caste. The question of housing access. So that's one, but anyway, welcome that it says that demonstrable data is needed, evidence is needed. The second very important landmark feature, and which also comes to your first question to Ashwini ji, is the fact that states are empowered to decide. And while you talked of the fact that it can lend to politics, I think politics responds to social needs, and this decentralization is very, very crucial. Also, in recognition of the fact that we must understand that there's considerable diversity of who are the vulnerable jatis within of a particular caste group, within of the scheduled caste group. We know scheduled caste groups are not homogeneous. There's a considerable diversity across states of who's more vulnerable in one state and who's lesser vulnerable in other states. So I think it allows for that recognition, and that it's welcome. Thirdly, and rightly you pointed out, it reverses the 2004 Chinnaiah judgment, where the hinge was homogeneity, and we all know that caste is multi-layered trauma, it's multi-layered oppression, and within castes are also hierarchies, within tribes are also hierarchies, particularly vulnerable tribal groups, for instance. So there is no one homogeneous treatment, and in that it's welcome. And fourthly, I think that's where the debate needs to be. The court says, I mean, that's how I looked at it, that the reasons, privileging of underprivileged castes or giving higher, it sets a limit for quotas. So you can't have a situation, as I read the judgment, where the guise of giving reservations to an underprivileged groups becomes a reason for denying reservation to some other groups. Now here is where the question of creamy layer comes. The court, the judgment, there are 4 of the judges have views within that 7-member bench on what the creamy layer is about, how they look at creamy layer. and the question of how to deal with creamy layer, but I think the judgment talks about a policy for creamy layer. I think on that we need to be cautious, Vinayji, because the argument can be, and the argument is, that the issue of creamy layer is, you have centuries of oppression, centuries and centuries of oppression, and you have generations and generations of people who have suffered on account of that. So social history is like that. So one reservation to one generation cannot undo all the wide variety of history of oppression. So I think that's something to be looked at, and also it cannot be treated on an individual basis. The fact also remains, if you're talking of data, the fact also remains that we probably need to review the data. We probably need to collect the data of what happened to 70 years of reservation. The jobs which were reserved, delisted to open category, and continue to be delisted to open category for various reasons, we need to look at. So the cake in that sense, although limited, is not extremely limited. There are still, as I speak, vacancies around, whether in recruitments or whether in promotions, which are reserved and which never get occupied, and it's ultimately opened up. So I think that's another sort of dimension I want to put in. And finally, I want to say that, you see, reservation is not a panacea. Reservation was, as Dr. Ambedkar says, reservation is a transitional measure. Reservation cannot be a panacea for either resolving all the caste issue or annihilating caste. Expectations in these last 70 years, 75 years, was for a contingent and an important role of the welfare state in creating social opportunities, in creating economic opportunities, in having land reforms done, in having decent work or decent wages or decent sort of livelihoods made available for the range of castes and groups of India, for housing, for healthcare, and those things haven't happened. The fact that we are debating reservations so much is a castigation of what our social and economic policies have been with reference to welfare of our majorities over the last 70, 75 years. So I think the reservation itself has to be seen within a wider perspective. This debate itself has to be seen within a wider perspective. That's what I'd like to submit in the first instance, Vinayji.
Manasvi, what do you make of this? The top court also clarified that none of these castes categorized as scheduled castes could be completely deprived of the quota benefit by a state in the guise of providing reservation to those who are not adequately represented in government jobs or admissions in educational institutions. That is also something which is homogeneous in nature.
I think this is a very apt time for this judgment to come out for the country, because this
why do you think it's apt? Why do you think it's the apt time? The Lok Sabha elections are over.
Apt time in the sense the country is moving forward, and there are backward classes in the scheduled caste and scheduled tribes, and that needs to be brought up in the mainstream. And this judgment makes it a great category of between heterogeneity and homogeneous caste. So in EV Chinnaiah's judgment, it was all about the scheduled caste was a homogeneous group. And while India is moving forward, and there was in the ground level, it was an understanding that it would be a great judgment and the implementation would be good, but the implementation was not good. There were subclasses in the scheduled caste which were required to be brought in the mainstream, and now it's a great opportunity for the backward classes in the scheduled caste to be brought up by the state, and the prerogative is with the state government. So I think now, since we have moved 20 years from EV Chinnaiah's judgment, so what is going to happen now? Preferential treatment will be given to backward classes in scheduled caste. That is the prerogative of the state. The onus would be on the state to bring and give an equal opportunity to all the castes. So earlier, some some classes in the SC were given some kind of benefits. Now everyone will given that kind of benefit. So that would be a great thing for the country moving forward. So that's why I'm saying it's an apt time. So the sub-classification in by no means what was believed in the EV Chinnaiah's judgment was against the principles of the Article 14 and Article 341, which with this judgment makes a very much clarity towards how the sub-classification can happen, and it is permissible. So from that perspective, I am saying that it's a great system for which we can move forward. So the backwardness which was there in the scheduled caste, so that is something which was not looked out. That was not something which was taken care by the state governments. But now the representations will be brought into table. Now the regions of backward which was not touched by the states or by the leaders will be taken up very seriously. Now this is going to be a great path for those who have not been touched by the benefits of the government. So that's why I think it's a great move by the Supreme Court, which gives a great momentum for the country moving forward.
Advocate Jindal, your thoughts on this judgment and how landmark it is, and what kind of changes are we going to expect when it comes to these reservations and these classifications, and a slew of issues that have also existed between the center and states also in terms of dealing with this kind of a concept.
Yes, definitely. If we are talking about the judgment only, yes, definitely the great judgment. Why we are saying this? Because there are certain categories which is we are deprived, that has been deprived from the getting the SC/ST category reservations. So now after this judgment, the categories which have not been touched, basically the panelists are also saying, now they can come into the category, and inequality, I can say that inequality in the reservation, now it can be changed. Every person who is deprived, who has been not taken care by the or deprived for any kind of this thing, then now by virtue of this judgment, we can say that yes, now the fresh persons who has been already been deprived with their rights, they can add it into SC/ST categories reservation and all. The other part is which we are talking about the state issue. The state has given power to how these reservations subcategories can be created. So this power has been given by our constitution to the state. The only thing is, apart from politics, the state should see how will this subcategory can be added on, and the persons who have been deprived from their reservation categories, they will get the appropriate place and appropriate reservation after this judgment. One more important point in this judgment is creamy layer. So now, as 9 judges bench in the Sahani case already been told, but that has not been taken care. But now the fresh judgment in 4 of the judges has already been stated about creamy layer. So creamy layer, I think it should be taken care, because the person who has already get benefits, they are by virtue of this particular reservations, they are getting benefit to the pass to the other centuries. So I think it would be taken care, and a person who get once this reservation, it should not be granted next time. If someone out of that particular category or having that status of having benefit of this reservation, I think it should be stopped, and creamy layer thing should be created by the state or central.
All right. We've run out of time. We'll take a closing and concluding thoughts from all our panelists, starting with the Advocate Ashwini Dubey.
विनीत भाई, SC/ST से क्रीमी लेयर की पहचान कर उन्हें रिजर्वेशन से अलग रखना, दिस इज द जेनेसिस ऑफ द जजमेंट, एंड दैट वाज द जेनेसिस ऑफ द जजमेंट ऑफ इंदिरा साहनी. Means those who have already got the reservation and those who have already come out from the vulnerable or downtrodden community, they or their children should not get the benefit, and those who are still struggling to come in the main dhara, mukhya dhara, vikas ki dhara, they should get it. 1 and 2, so far as the classification, so far as the identification of SC/ST community is concerned, that is not the exclusive domain of the central government, that also now permissible to be exercised by the states. यानी विनीत भाई, अगर राजनीति को बाहर रख दे तो कॉन्स्टिट्यूशन का जो मूल आधार है कास्टलेस सोसाइटी की, उसकी तरफ बढ़ता हुआ ये एक कदम है. जी
मिस्टर चाचा.
I think I want to say that the power of the state governments to determine who is in the SC list, which are the groups, or ST list, I think that's very, very important. Otherwise, it takes years to, in our nature of our democracy and bureaucracy, goes to the president. So it's a fantastic change, and it responds to social needs on the ground, number 1. Number 2, I also do think that this is somewhat contained, and it's important by the need for evidence and data. So the judgment clearly says that please have evidence and data of vulnerabilities while doing so, and that opens up the whole discourse on the need for caste, socioeconomic and caste census, which is very crucial. I think the third point, and very briefly on the creamy layer, as I said earlier, the question of creamy layer is indicative in the judgment. It needs a policy and it needs a lot of social debate. Creamy layer, one generation, centuries of oppression and everything expected to be corrected, in one generation, despite the fact that other welfare provisions haven't worked, many instances I gave. I think that question should not be seen in that limited perspective of a family, of an individual. It doesn't quite reverse like that. One gentleman who has become a peon or a sub-divisional officer or even an officer from a village in the state also already supporting a lot of the community. That's how reality is. So we should not view the question of creamy layer from the narrow lens that this person is really out of the need for reservation. And I think the court is conscious of it. So the court clearly says that, the guise of giving reservation to a genuinely demanding group, and the limits have been set, should not undo the reservations for the more homogeneous scheduled caste group. So I think that's important. I welcome the fact that many communities, such as the denotified communities, the nuts, the good judges, there's so many denotified communities who are currently within the scheduled caste groups or the scheduled tribe groups, will and have been denied or have not been able to access reservation given the social histories of stigma and criminalization, have now open pathways to get into a sub-categorization and therefore reap the benefits of reservation. Thank you, Viniji.
All right, Manasvi.
I feel as India is moving forward, and when we talk about India first and the growing power of India, I think this is very important for all those subcategories which in the scheduled caste have been deprived of any kind of preferential treatment will be given this opportunity now with this judgment, if it is taken up in complete letter and spirit of the judgment by the state governments and by the central government together, and the political parties most importantly implement this judgment in its true spirit. I think that the left out backward categories or in the backward classes will get an opportunity given from the Supreme Court to move forward in their lives, and something which was taken as an inheritance from generation to generation and enjoying the benefits of being in a scheduled caste, and those groups which were untouched with the preferential treatment will now come in the mainframe, and that's a great step for a country as diverse as India to give equal opportunities and it has to match up with the creamy layer concept in totality. It cannot be untouched. It has to be matched up. Equal opportunity has to be given to a family. Once it is out and it is considered to be a creamy layer, it should not be given that kind of a benefit anymore. Right. Only then 140 crore plus people will get that benefit.
All right.
That has to pass.
Advocate Jindal.
This judgment told all political parties a person who is taking undue advantage of reservations. So this judgment say, please stop all this and give the benefit those who are needed.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.